Did you know there is an area of Yellowstone National Park where you could get away with murder? This zone of death exists because of a loophole created by the U.S. Constitution. To understand this loophole, you first need to understand the boundaries of Yellowstone National Park and how laws are enforced in the park. The park exists in the western United States, in the states of Wyoming, Idaho, and Montana. While the great majority of the park is in Wyoming, a small northeastern portion of the park is in Montana, and a small western part of the park is in Idaho. Additionally, as a national park, the park is federal land, and laws are enforced by the federal court system, rather than the state court system. In the case of Yellowstone National Park, Congress assigned the entire park to the Wyoming US District Court, even though the park is in 3 different states. This makes the Wyoming US District Court the only U.S. District Court that includes land in multiple states. This sets up the constitutional loophole. The U.S. Constitution states in Article 3, Section 2, that a trial shall be held in the state where the said crimes shall have been committed. This means if you commit a murder in the Idaho portion of Yellowstone National Park, you must be given a trial in Idaho. Additionally, the Sixth Amendment to the U.S. Constitution further states that the defendant is entitled to a trial by an impartial jury of the state and district wherein the crime shall have been committed. This means that a crime committed in the Idaho portion of Yellowstone National Park would have to be tried before a jury of 12 people who reside in the state of Idaho and also reside in the judicial district of the Wyoming US District Court. This results in only being able to select jurors from this small area here. The problem is, no one lives here. Therefore, unable to find jurors from the state and district where the crime was committed, you could not be convicted of murder by trial by jury, and the federal courts could not convict you. This loophole has yet to be exploited, but a similar case happened in 2005 when a poacher illegally shot, killed, and dragged an elk to his car in the Montana portion of Yellowstone National Park. The Montana portion of the park does have a few residents, but still, putting together a jury of 12 people would have been hard. The poacher knew this and objected to being tried in Wyoming by Wyoming jurors, under Article 3 of the U.S. Constitution and the Sixth Amendment. However, the Wyoming District Court judge rejected the poacher's motion, stating to adopt a different position would create a virtual no man's land. Since there is no case law that states otherwise, this court must dismiss the defendant's objection. The poacher could have appealed the judge's ruling to the U.S. 10th Court of Appeals. However, instead the poacher took a plea deal conditioned specifically on not appealing the zone of death issue. I think this was a poor outcome. In his ruling, the judge clearly put the court's ability to convict the poacher over following Article 3 of the Constitution and the Sixth Amendment. While it was important to convict the poacher, disregarding a defendant's rights to a fair trial as outlined in the Constitution sets a dangerous precedent. Disregarding the Sixth Amendment in this case resulted in the more fair outcome, but disregarding the Sixth Amendment in another case could be used to pick a non-local jury with a prejudice against the defendant, undermining their right to a fair trial. I think a better argument would have been that holding the trial in Wyoming is okay because it achieves the purpose of Article 3 and the Sixth Amendment, that a community governs itself through not only the election of its leaders, but also the enforcement of its laws. In this case, the community impacted was the Yellowstone National Park community, so the best group available to be the jurors would be the residents of Yellowstone National Park, who in the vast majority live in Wyoming. What do you think? Do you think the poacher could have won the appeal? What would the outcome would have been?